Mr Acting President, the New South Wales Anti-Discrimination Act provides protection for citizens against discrimination and vilification across a range of personal identities. It functions mainly as a safeguard mechanism. By international standards, we live in a tolerant society in New South Wales where people believe in equal opportunity. Cases of genuine discrimination, thankfully, are rare. Most citizens judge people by their work ethic and character, not their race, gender or sexuality. Identity politics, I would argue, is the antithesis of the Australian way. The risk, therefore, with the Anti-Discrimination Act is one of misuse. If it is too legalistic, too open to vexatious complaints, it can be exploited by political activists for the wrong purpose. It can be used for personal feuds and political campaigns rather than justice and the fair treatment of citizens. This parliament needs to be vigilant in protecting the Act's integrity. We must ensure that anti-discrimination provisions are not abused, that activists do not use them as a blunt instrument for personal financial gain or vengeance, or for political purposes, trying to silence those who simply hold views with which they disagree. Such activism would not only be morally wrong, but also represent a misallocation of scarce resources in the New South Wales legal system. In developing this statute, the New South Wales Parliament foresaw the possibility of frivolous and vexatious complaints being lodged with the Anti-Discrimination Board. Section 92 of the Act gives the Board's President authority at any stage of an investigation not to proceed with the matter. Among other reasons, the complaint or part thereof may be discontinued if the President is satisfied that, and I quote, "the complaint is frivolous, vexatious, misconceived or lacking in substance. The conduct alleged, if proven, would not disclose the contravention of a provision of the Act or the regulations. The nature of the conduct alleged is such that further action by the President in relation to the complaint is not warranted. And finally, it is not in the public interest to take any further action in respect of the complaint." Unquote. Under Section 93A, once the President has discontinued an investigation, I quote, "the complainant may, within 21 days, require the President by notice in writing to refer the complaint to the tribunal." End of quote. That is, in effect, an appeal process to the New South Wales Civil and Administrative Tribunal, NCAT. This is a second bite of the cherry, eating up scarce resources in the New South Wales legal system at a time when court backlogs are long and getting longer. These NCAT appeals are also incongruous. Under Section 89B(4), a decision by the Anti-Discrimination Board to decline a complaint in whole or in part is not reviewable by the tribunal, yet a decision to discontinue an investigation is reviewable, a clear inconsistency. The role of the Anti-Discrimination Board in relation to complaints is one of conciliation. It does not make determinations on the merit of complaints. If after 18 months conciliation has failed, then under Section 93B, the complainant, if he or she insists, has the automatic right of referral to NCAT. The Act allows complaints to be lodged without cost. NCAT determines complaints referred to it as part of a no-cost jurisdiction. A complaint may result in a penalty of up to $100,000 issued by NCAT payable to the complainant. If complainants have legal prowess, they can represent themselves and indeed make a tidy profit. Given these provisions, the vetting of initial complaints lodged with the Anti-Discrimination Board is vital. Once a complaint is in the system, the matter can drag on for years and inevitably end up at NCAT, with the possibility of substantial financial penalties plus legal costs for respondents not able to defend themselves at the Board or at NCAT. Respondents can feel harassed and stressed by such a lengthy period of legalism, especially if they're also subject to media publicity due to the action. These things can become a nightmare. Unfortunately, the threshold for the acceptance of complaints at the Anti-Discrimination Board is minimal. Under Section 89, it requires complaints to be lodged in writing and they need not demonstrate a prima facie case. Section 89B(2) limits the President's powers to decline complaints to matters more than 12 months old, those outside the scope of the Act, where someone has falsely lodged a complaint on behalf of someone else, and in vilification cases where the person making the complaint does not have the characteristic allegedly being vilified. The President may decline in these circumstances. There is no requirement, as per the practice in most other states and territories, that the President must decline the complaint. Clearly, Mr Assistant President, these provisions are open to abuse. There is next to no restriction on lodging complaints. It is free for political activists to target their opponents and use the Anti-Discrimination Board and NCAT as political weapons, tying them up in legal disputes and costs, but at no cost to the complainant. This is a form of lawfare, one of the worst trends in modern politics. Activists are using the legal system to try and score the political points they cannot achieve by democratic means. Or even worse, they're using the legal system to try to destroy their opponents financially, to break them with the cost of using lawyers and going through tribunals to defend themselves. This is not justice, it's a lawyer's picnic. In the 4 decades since the Anti-Discrimination Act was legislated, the political environment has changed substantially. We now live in an era of heightened political activism, much of it driven by the intense, polarised and at times obsessive nature of social media. Tactics such as deplatforming and cancelling culture have become common. The Board and NCAT should not be pawns in this game at taxpayers' expense, therefore requiring under the provisions of this bill amendments to the New South Wales Anti-Discrimination Act. Mr Assistant President, the clearest example of this new reality is the long-running feud between Gary Burns and Bernard Gaynor, the 2020 New South Wales equivalent of the Hatfields and McCoys. In this case, the aggressor has been Burns, a self-described gay rights activist, who has stated publicly his work, he says that, his work is to lodge complaints with the Anti-Discrimination Board. Hundreds have gone in, the vast majority accepted under Section 89. Burns has also sent scores of abusive emails to those he's complained against. Many MPs have received correspondence from Mr Burns, going back to the days of the Carr government. There's no doubt that he is very obsessive about this agenda, and is someone who, in the eyes of many MPs, myself included, is not genuine in the pursuit of justice through the Anti-Discrimination Board. At a time when the New South Wales court system has a huge backlog of matters, it's incredible that someone like Burns has been able to eat up resources elsewhere in the legal system at the Anti-Discrimination Board and NCAT. He's been treated as a credible complainant for these hundreds of matters, when the scores of items he's forwarded to my office since March 2019 clearly shows he's not of sound mind. He frequently condones and advocates violence such as the bashing death of George Pell. He displays many of the characteristics of a fantasist, inventing meetings that never took place, making up conversations that plainly didn't happen. I could cite other examples to the House, Mr Assistant President, many of them, but they're indeed erratic. I'm willing to make my hefty file of Burns' emails available to any MP who wants to understand the seriousness of what we're dealing with here, but I know that other MPs have a comparable file. Rather than being given a platform by the Anti-Discrimination Board and appearing at New South Wales Tribunal and court hearings, Burns needs assistance of a different kind. One of his many emails was directed at Bernard Gaynor, a Catholic blogger and father of 8 who lives in Queensland. Gaynor once said he didn't want his children taught by gay teachers, and Burns has been at him ever since. The Burns email states, and I quote, "Mr Gaynor has an asset, namely his house. So if there's enough complainants and the complaints are substantiated, we can look at taking his house through bankruptcy." End of quote. In fact, Gaynor has had to sell his house to pay the legal bills racked up by his fight against Burns. This is clearly an example of lawfare. Burns is not looking for natural justice. He's looking to financially ruin the Gaynor family for no other reason than that they've become antagonists and hold political and moral beliefs different to his own. His vilification complaints are, in fact, a form of counter-vilification. In public opinion, they would clearly be regarded as vexatious. We can be certain they are not what the founders of the Anti-Discrimination Act intended in the functions of the board. Mr Gaynor has faced 36 complaints from Mr Burns, with 18 going to NCAT. None have been substantiated, but has cost Gaynor hundreds of thousands of dollars to defend them. Some people would fold, but Gaynor has fought on as a matter of deep principle and religious belief. He has been tied up in litigation since 2014 with no end in sight. Burns has even been able to lodge homosexual vilification complaints against Gaynor, even though Gaynor is a Queensland resident. The New South Wales Parliament has no jurisdiction over other countries, states and territories, yet this madness marches on. Where will it end? Are our tribunals also going to deal with complaints against Australians living overseas, or even the citizens of other countries non-resident in New South Wales? Gaynor recently received his 37th complaint, this time for sharing on his Facebook page a petition from the Australian Christian Lobby against an event called Drag Queen Storytime in Brisbane City Council libraries. That's right, Mr Assistant President. At a time when the New South Wales legal system cannot police the vast number of AVOs issued, when alleged victims of sexual assault have to wait 2 or 3 agonising years for their matters to be heard in court, when legal aid resources are incredibly scarce, when the system is clogged up and overflowing with justice delayed and justice denied, we are spending state government money on policing a Facebook page on a municipal issue in another state. How has this jurisdictional farce been allowed to continue? In February 2017, the New South Wales Court of Appeal found that NCAT had no jurisdiction over Gaynor. He was a resident of another state. In April 2018, the High Court of Australia upheld this ruling, finding that the Australian Constitution prevents tribunals not properly constituted as courts from resolving disputes between interstate residents. During the course of this legal action, the New South Wales Government responded by passing laws giving the New South Wales Local Court power to resolve NCAT disputes between interstate residents. The New South Wales Attorney-General was concerned that the court rulings would prevent fair tenancy matters being heard at NCAT when the offending landlord was based in another state. That's a legitimate concern. But the passage of that statute has allowed Burns to use the legislation to continue the targeting of Gaynor. In June 2018, the Anti-Discrimination Board referred 3 new unresolved complaints about Mr Gaynor to NCAT. Significantly, and I think it's very important, Mr Assistant President, Burns has not lodged complaints against Gaynor in the state where any alleged offence is most relevant, in Queensland. Under the Queensland 1991 Anti-Discrimination Act, section 139, Queensland has a higher threshold for the acceptance of complaints, such that, and I quote, the Commissioner must reject a complaint to the Commission if the Commissioner is of reasonable opinion that the complaint is frivolous, trivial or vexatious or misconceived or lacking in substance, end quote. So, Mr Assistant President, this points to forum shopping by Mr Burns, using the New South Wales legal system and its resources because he knows in the acceptance of complaints it's the easiest way to attack a Queenslander. He doesn't lodge them where the statements have been made or where the respondent lives. He lodges them here in New South Wales because we have the low threshold. He's forum shopping and we've become a soft touch for these actions and the expenditures that go with them. Notwithstanding the Court of Appeal and High Court rulings, a common sense response from the Anti-Discrimination Board would have been to tell Burns that his file is full, that the New South Wales government agencies are not there to process endless complaints from litigious types pursuing personal feuds and vendettas against interstate residents, that Burns's complaints would no longer be accepted. But this kind of sense is far from common at the Anti-Discrimination Board. The Burns-Gaynor dispute has involved scores of matters, years of litigation and millions of dollars of public money washed away for very little purpose. As the Board and NCAT are no-cost jurisdictions, Burns has been able to represent himself and clog up the system, making this his full-time, cost-free vocation. Last year, Mr Assistant President, I raised the problem with the Attorney-General, Mr Speakman, but he's done nothing. This is a matter an Attorney-General should care about, to close down the reckless abuse of the legal system for which he's responsible and to carefully protect the proper allocation of taxpayers' resources. Some of us, of course, do care. Some of us believe the New South Wales legal system should be based on professionalism, efficiency and a clear duty of care for the administration of justice. It shouldn't be the plaything of political campaigners at public expense, as the government and the Anti-Discrimination Board have allowed it to become. Mr Assistant President, seemingly no one is free from Burns's campaigning. If anyone mentions the word gay or homosexual in any negative way, he will use the Anti-Discrimination Board for retribution. His targets have included John Laws, Jeff Kennett, the singer Rob Mills. I don't exactly know what Millsy did wrong, but he's been up through this action, and also a series of election candidates. In any given year, it seems at least one half of the homosexual vilification complaints lodged with the Board are from Burns. The worst example, and this is sort of a sad instance, concerns a former New South Wales taxi driver, John Soonall. In 1978, Soonall was involved in a car crash that left him brain damaged. Soonall has used social media to rant about gays in a random, incoherent fashion befitting his level of incapacity. He has few followers, no real impact and no political influence, which sadly has made him a target for yet another Burns vendetta. Scores of complaints have been lodged against Soonall, first by Henry Collier and then Gary Burns. More than 20 cases have come before New South Wales tribunals and courts. Soonall is said to owe Burns more than $50,000 but cannot pay, having been bankrupted in 2014. The legal types are now circling the trust fund that controls Soonall's $400,000 compensation payment for his accident. It seems today that Burns is the only person who cares about Soonall in a vindictive and rational way through this lawfare. He's told NCAT he set up a Google alert for every time Soonall posts on the internet. So this is what the New South Wales legal system has become: a cruel, bizarre forum where political campaigners can pursue intellectually disabled people for comments with zero social and political impact, and we're paying for it. The Anti-Discrimination Board is supposed to protect the disabled, but in a perverse turn it has used its authority to persecute a poor, hapless soul like Soonall. These people ought to be ashamed of themselves. They're not protecting the vulnerable in our society. They know Soonall's condition. They know the wrongness of what's happened, yet they've left him defenceless against a serial litigant. And I want to point out also, Mr Assistant President, there's a clear pattern to Burns's complaints. They are designed for maximum political coverage rather than legal justice. In early December 2019, Israel Folau and Rugby Australia announced they'd settled their long-running employment religious freedom dispute. Rugby Australia apologised to Folau and his family, acknowledged he meant no harm or offence in his social media postings and paid him substantial compensation. 9 days later, the Anti-Discrimination Board informed Burns that it had accepted his complaints about Folau, concerning Folau's 2019 social media post about sinners going to hell, plus comments Folau had made to his congregation as a church pastor in November 2019. Folau said that God was unhappy that the passage of federal same-sex marriage and New South Wales abortion laws, and this was the reason for the East Coast bushfires. Burns issued a press release promising that, and I quote, "Folau is about to cop a dose of third-degree burns." This is the kind of nonsense we're dealing with, and the Anti-Discrimination Board continues to embolden. I made representations to the Board President, Annabelle Bennett, in December asking on what basis the Burns complaint had been accepted. She replied as follows: "As you would be aware, complaints are lodged with the Anti-Discrimination Board. They're dealt with as provided by the Act. The acceptance or declining of a complaint as lodged is set out in the Act. If the criteria for declining a complaint as set out in section 89B do not apply, the complaint must be accepted. Therefore, a complaint is investigated. At any stage of the investigation of a complaint, it can be declined for the reasons set out in section 92 of the Act." I responded as follows: "I'm sorry, Annabelle, but I can't understand how the Anti-Discrimination Board can accept a complaint about someone exempted under the Act. Israel Folau grew up in Minto, a born-again Christian Islander community. I know it well because I represented them in the federal parliament. Minto was a public housing estate, a struggling district. In comparable parts of Campbelltown, the parents were unemployed and the kids too often in trouble. Minto was different, due to the influence of religious faith. The Islander community found purpose and direction through their born-again Christianity. It was relatively trouble-free. The kids stayed off the street and out of jail. The young Folau was one of them. His father was heavily involved in religious activities, setting up a church of which his son is now a preacher. This is what multiculturalism looks like. This is what freedom of religion looks like." And I said to Ms Bennett, "You and I would barely believe a word of the Old Testament, but for this community it is gospel, subject to literal interpretation. It is giving them meaning and faith in life. Israel Folau believes in the wrath of God manifest in recent times, he says, through bushfires punishing our society for same-sex marriage and the New South Wales statute. Israel Folau believes in the word of Corinthians, that large number of sinners need to repent or face hell. Israel Folau is a preacher in his church who has come to public attention because he's lost his job at Rugby Australia due to his expressions of faith. I also pointed out, Mr Assistant President, it was never the intention of the New South Wales Anti-Discrimination Act to pursue the churches and the words of those who preach in them. This is clear in the exemptions at section 56 and 49ZT. Nothing in the Act is to affect the, and I quote, act or practice of a body established to propagate religion that conforms to the doctrines of that religion. Similarly, specifically in relation to homosexual vilification, and I quote, nothing in this section renders unlawful a public act done reasonably in good faith for religious instruction, including discussion and debate about and expositions of any act or matter. I concluded by asking the board president, how can a complaint about someone exempt from the Act be accepted by the board? That's what I can't understand. I've never heard of a government body that pursues people exempted by law. Ms Bennett replied, thanking me for my email, and said she was fully aware of the exemptions and of Section 92. However, it's a matter between the parties, including to provide information. She said that Mr Folau will be invited to respond, and she would then consider the information that he provides and other relevant matters. One would have thought the Anti-Discrimination Board, Mr Assistant President, was there to administer the Act under which it is established. If it knows Folau to be a religious preacher, and it does due to the extraordinary publicity he's received, then logically it should rule he's exempt from the Act and the Board's jurisdiction. But Ms Bennett has a different, rather unorthodox approach. Folau and his lawyers have to prove their own exemptions. They have to administer the law on behalf of the Anti-Discrimination Board. Ms Bennett has accepted the Bird's complaint even though she knows the respondent to be exempted under the Anti-Discrimination Act. As of February 2020, the complaint against Folau has not been declined under Section 92. He has incurred further legal costs and been subject to even more, I assume, stressful publicity in his circumstances. Even though Folau is now living in France to play rugby league football, he's still being pursued by the New South Wales legal system on matters for which he's exempt under New South Wales law. This is the weird world of lawfare that unfortunately Mr Speakman and Ms Bennett are fostering. Thus, Mr Assistant President, a private member's bill is needed to restore balance and fair, streamlined processes to the work of the Anti-Discrimination Board. The era of serial political persecution must end. Mentally disabled citizens such as John Soonall must be protected. Significant cost savings can be realised by streamlining the complaint processes of the Anti-Discrimination Act. This bill, the Anti-Discrimination Amendment Complaints Handling Bill 2020, seeks to achieve this in 6 ways. First, it repeals Section 93A such that in future referrals and appeals to NCAT for matters discontinued during board investigations will no longer be possible. This brings the Act into line with Section 89B4. Consistency is crucial. If NCAT has no role in overturning complaints refused, it should have no role in overturning investigations discontinued by the Anti-Discrimination Board. Under the current laws, the Board commonly accepts frivolous and vexatious complaints. That in itself is bad enough. But if the Board, in a rare moment of common sense, decides to terminate an investigation into a frivolous and vexatious complaint, this is where the matter should end. It has accepted the matter, it's examined it and decided it's without merit. There is no need for the matter to go up the chain to NCAT and possibly appeals to the New South Wales court system. Second, the bill inserts a new clause at 89B2J requiring the President to decline a complaint unless satisfied that one or more of the respondents is an individual who's made a complaint to which the complaint relates at the time of making the complaint was 1, a resident of another state or territory as evidenced by the individual's address on the electoral roll, and 2, not in New South Wales. This updates the Act to take account of the new media environment. When the Anti-Discrimination Act was established, there was no such thing as social media. Yet today, most of these vilification matters arise on social media platforms. The new clause respects the proper jurisdictional limits of New South Wales law by disallowing complaints against individuals who were not in the state and not residents of New South Wales at the time of making the alleged offensive media comments. Individuals allegedly offending on social or traditional media should be pursued under the laws of their home state or territory. New South Wales should not be a soft touch for forum shopping, dragging in interstate cases against respondents because the threshold for complaint acceptance in our state has been set too low. We shouldn't be dedicating parts of the New South Wales government legal budget to what someone in Perth, Brisbane or Hobart has said on Facebook. In the acceptance of complaints, the bill exempts interstate residents making media statements, traditional and social, unless the complainant can show to the President's satisfaction that the comments were made in New South Wales. Other revisions with regard to interstate entities and residents are unaltered. For instance, Mr Assistant President, if a business operating in New South Wales discriminates or vilifies a protected class of persons, complaints can still be lodged against it, even if the owners and managers live interstate. If an individual from another state or territory comes to Sydney for the day and marches around Martin Place with a placard vilifying certain people, a complaint can be lodged and accepted. The proposed exemption is solely for interstate residents making their public comments interstate. Third, the bill ensures complaints cannot be accepted against people who have exemptions in other parts of the Act. For example, churches and those who preach in them, as per the Falau example. If a complaint is lodged, the President of the Board must refer to other parts of the Act and ensure exemptions do not apply before accepting such a complaint. It's incredible that we need to legislate this way for the President to do a job, to do something that you would assume is already automatic in the administration of the Act. But that's where we are in 2020 in trying to hold back the flood of politically motivated vexatious complaints. Fourth, under a new section 89B2L, the President must decline a complaint is satisfied the respondent has a cognitive impairment and it is reasonably expected that the cognitive impairment was a significant contributing factor to the conduct that is subject of the complaint. If a complaint is lodged, the Board President should not accept it if it's known to her that the respondent has an intellectual disability, a developmental order, including an autistic spectrum disorder, a neurological disorder, dementia or a brain injury. In the Soonall matter, the Board has long known the truth and should have protected him from vexatious complaints. Under the proposed amendment to the Act, there will be no more cases like this. Once the intellectual impairment is known, contributing to the alleged behaviour, activists like Burns can no longer seek to harm the disabled. Mr Assistant President, this is a sensible updating of the Act, again to take account of the impact of social media. Plainly, the Soonall scenario was not possible in 1977, but today, unfortunately, given the open, unregulated nature of social media, these things are possible, and we shouldn't be eating up the legal resources of New South Wales to deal with them. Fifth, the bill adds clarifying clauses to section 89B2 governing the acceptance or declining of complaints by the President. In looking at how other states handle this threshold question, the provisions in Queensland, South Australia, WA, Tasmania are similar, setting a higher, more realistic standard than New South Wales. We lag behind other jurisdictions in the streamlining of anti-discrimination provisions and the effective use of state resources in this aspect of the law. So my bill proposes to adopt, in effect, the standard threshold provisions that are operational in other states and territories. Why New South Wales hasn't done this any time in the last 43 years is hard to know, but it should be done now. We should also ensure that matters that can be dealt with satisfactorily in other jurisdictions are left at that point. In the Falau matter, for instance, why should New South Wales legal resources be used for an action replay of a matter already dealt with, conciliated on and resolved to the satisfaction of both parties in the Commonwealth Fair Work Commission? So we should set the threshold and also the guidance that other states have used that if a matter's been dealt with satisfactorily elsewhere, it no longer needs to eat up the resources of that state. Finally, Mr Assistant President, the bill seeks to strengthen the obligations of the President in declining and discontinuing complaints. In both sections 89B2 and 92(1), it is proposed to change the current discretionary wording, the President may, to bring it into line with interstate practice. That is to make a more definitive provision whereby the President must follow the requirements of the Act in ruling out complaints. I should point out to the House this bill will not affect any complaint currently lodged with the Anti-Discrimination Board. It has no retrospective provisions. It takes effect only when it passes into law. And I would also briefly draw attention to the House to the bipartisan way in which the Federal Parliament has dealt with very similar provisions in amending their own Human Rights Commission statute. I hope that this bipartisanship can be extended to our Parliament. I hope to refer this bill to Portfolio Committee number 5 on Legal Affairs to examine the detail, hear from affected parties and hopefully reach a legislative consensus on how to proceed. Mr Assistant President, these reforms are long overdue. They modernise the Act, they bring it up to date in the age of social media. They allow the New South Wales Anti-Discrimination Board and NCAC to deal with crucial cases of discrimination and vilification without squandering resources on personal vendettas and political campaigns that have no place in this jurisdiction. I commend the bill to the House.
Thank you, Honourable Member. The Government Whip.
I move that debate on this bill be adjourned to 5 calendar days.
The question is the motion of the Government Whip. I put that. Those in favour say aye. Those against say no. The ayes have it. The ayes have it.
And, Mr Assistant President, I move, according to the contingent notice on the notice paper, that A, the Anti-Discrimination Amendment Complaint Handling Bill be referred to Portfolio Committee number 5 for inquiry and report, and B, on tabling of the report by the Portfolio Committee number 5, a motion may be moved without notice that the bill be restored to the notice paper at the stage it had reached prior to referral.
If there's no objection, I'll put the question, which is the motion of the Honourable Mark Latham. Those in favour say aye. Those against say no. The ayes have it. The ayes have it. The Clerk.